Hi, everyone. Welcome to our Facebook live broadcast. I'm Steve Altition, Director of Client Partnerships here at Pacific Cascade Family Law. And today I'm here with attorney Curtis Edmondson to talk about intellectual property issues in divorce and estate planning. Hey, good morning, Kurt. How you doing?
Doing pretty good, Steve. Good to see you again.
Good to see you too. So before we start, Kurt, could you just tell us a little bit about yourself?
Well, my background, I was a consummate engineer, grew up tearing down television sets, went off to college and studied electrical engineering, and then worked for Lawrence Livermore Labs, Hughes Aircraft, and then had a software company and went back to law school later in life and studied patent law. And since that time, I've been primarily doing patent, trademark and copyright litigation and other interesting things.
Well, you are the perfect guy to have today then. So Curtis, on some other Facebook lives we've been doing, we've discussed how intellectual property is subject to division and divorce, and it's also transferable in a will or a trust.
Mm-hmm.
But let's talk about some issues today that are unique to intellectual property that can happen, when there is a divorce or when you do have a estate planning property you want to transfer. And so to start, I'm just going to start with the real basic question. Just what is intellectual property?
That's a very good question. So there's really four areas of intellectual property. Patents, which are for inventions, and these are new processes, methods, things you create which improve things or devices that you build. And what that involves is going to the United States Patent Office, applying for a patent. It's looked at by an examiner. And at the end of the process, you get a patent issued, hopefully. And that patent is typically then used by a company. Ideally, it's licensed by a company, or you might use it in your own company to manufacture a product. And then people might pay you a licensing fee if they want to use that patent in the manufacturing of their own product. So I've worked with a lot of inventors, for example. In the course of their job, they'll invent things to improve their job. And then they'll go to companies who will make those devices. For example, in the medical device space, it's very common. You have a surgeon or an anesthesiologist or a physical therapist. They say, here's a need for a new type of device, a spanner, for example. Well, they don't want to be in the spanner building business. So they invent this, they get a patent on it, and they'll go to a company that makes spanners, and the company might say, we'll pay you 5% of our gross sales. And there are individuals who have made millions doing that sort of thing. The second area of intellectual property law is known as copyrights. And those are things we're very familiar with. They're expressive works, creative works of music, writing a book, writing a web page, writing software, these sort of expressive activities that are covered by the Copyright Act. And the copyright interest is not necessarily, it's created at the point of you writing it down, or you're singing the song, or you writing the software. And you can go to the Copyright Office and get a registration for that copyrighted work. And that is a very wise thing to do, but it's not a requirement to say you have that copyright interest. It's a little different than patents, but they share a lot of common characteristics. The third area of IP law is known as trademarks. And trademarks are rights that are associated with you either selling a product or having a service. So they go all over the map. Being here in Oregon, we're very familiar with Nike. Nike differentiates itself because it has a particular brand, and they might make a shoe for $1, and the ability to sell it for $200 is the strength of their brand. And so brands are very important to companies like Nike, Columbia. They're important to even companies like Intel, their Intel Inside branding for their chips. But it's also covers services. So for example, if you have a unique brand for a plumbing company, that in itself has a certain value because people will look up Bob's Plumbing in Tigard. I'm just using that as an example. I don't know if there is a Bob's Plumbing, but then that's something that becomes a brand that can be searched by the Google search engine. You might want to then get a trademark for that, so other people can you prevent other people from using the same mark. So that's a trademark, and a trademark is something that comes into existence from you either selling a product or performing a service. So trademarks, as that third group, is directly connected to your business activities, whereas copyrights and patents are creations of the mind, and we call them inchoate rights. You don't necessarily have to sell them or use them to have those rights in existence, whereas trademarks is a little different. The last area of intellectual property law is commonly known as trade secrets. And so these are things that are secret, but you don't disclose to anybody else. And the one we always refer to in our business is the recipe for Coke. In theory, nobody knows what it is, and it's a trade secret, and it's held in a vault somewhere. Likewise, what is the 11 herbs and spices of Kentucky Fried Chicken? Well, the myth is nobody knows what that is. And as long as you keep something as a trade secret, it has intellectual property value. And that can be a wide range of things. For example, if you have a business and you keep a list of your customers, those customer lists can be considered trade secrets, because not only do you have those list of customers, you might have some notes, well, this customer likes to be called on a Tuesday. And that knowledge that you've gained by working with that customer over time has real value to it. So those are the four general areas of intellectual property law. Where these come in to play is, when does that right or that interest attach to the person, and how does that interact with these life events of marriage, divorce, death, and all, it's those things that Steve and his firm are experts in. But when these events happen, you talk to intellectual property professionals to help value what these interests are.
Is there ever an issue on who owns the right? And I guess what I mean by that is, in a patent, I assume that the person who files the patent obviously files to be the owner of that patent, potentially. And that person has a thing of value. If they sell it, let's say, to someone else, first of all, can they do that? Can they take something that they own like that and just say, here, it's yours, you can use it?
Yeah. So each area of law has little different quirks to it. They share a lot of common characteristics, but we'll go through each one. For a patent, when you as the inventor, or there can be more than one inventor, there's co-inventors, create something, the ownership of that invention attaches to the inventor at the start. And then typically, if, for example, you work for a company, there's some sort of agreement or contract where that invention is assigned to that particular company. That's usually part of an employment agreement. But it's not uncommon for a garage inventor or somebody doing things on their own to just think of something on their own and and file for a patent themselves. That ownership right is personal, and whether it attaches to the marital estate is probably is some controversy, because, well, you have the inventor who's doing things in the basement, inventing these things, but clearly his wife or husband or partner is contributing to the marital estate and may have contributed to the things needed to make that invention. And that's where a lot of these things can be clarified ahead of time, if there is, for example, a divorce, to clarify that at the point of divorce, because down the road, that invention might be something that becomes very valuable. And this is where the disputes come up. I'll give you an example. The woman invents a new type of syringe. She's the homemaker. The husband works at a big company. He's been supporting the family, quote unquote. And then they get a divorce, but they don't determine what that patent interest, how that's going to be treated under the divorce decree. Down the road, at that time of divorce, the patent might not be worth anything. There's no licensors for it. But she then, after divorce, because she's the purported owner, goes off and makes $10 million. And the husband then says, well, wait a minute. You got that patent while we were married. I should get half of it. And that leads to a lot of disputes down the road. So by valuing that particular patent at the point of divorce and clarifying, well, what's going to happen to it? If the patent is turned into something, then it'll be divided equally. Or another aspect of patents is, once the patent issues, every approximately 3 years, you have to pay additional money to keep it enforceable. Who's going to pay that money to keep it enforceable? Or are we going to let it go abandoned? The other thing too is that the patent itself typically has to be marketed to somebody who wants to use the patent. So who's going to pay for that marketing effort to make the patent of value? And those are things after divorce. I'm just using the divorce as an example, but it certainly comes up in the context of death, where the estate or the kids are trying to figure out what to do with this, patent that dad had or mom had. How do we deal with paying to have it marketed? How do we have to deal with paying for the maintenance fees? And it's better treated ahead of time while the people are still on good terms, or not so bad terms.
Yeah, that makes complete sense. Is there? Let's talk for a second about people. Let's say I didn't invent it, or I didn't write it, but I've been given the rights to use it or market it or something like that.
Yeah.
And we get, I get into a divorce situation. And the court says, okay, you're going to split that 50-50. And so you say, okay, I'm just going to, deed over to you, or, the decree is going to give you 50% interest in this. Can that cause some issues down the road? What if it's an exclusive, license? I mean, are there issues you can get into not knowing, what your actual rights are under a license or even an ownership?
Absolutely. So in the case of both patents and copyrights, typically, if there is a contract where somebody is using that particular right, like let's say your spouse was a singer and they have a contract with Warner Brothers for this song, and they're getting royalties on that song. And there is a contract there that obligates might obligate the artist or the author to do certain things, and as a condition for getting the royalties. If that contract is not reviewed by both parties and they just say, well, we're going to split it 50-50, what they do or don't do might impair those future revenues. So that's the problem when two people or three people or many people get partial interests to a right, is that they might not agree to what should be done with that right. There's a lot of similarities between this and owning a piece of real property. If because your father passes away and he leaves three kids a house, not all the three kids can agree to do what the house. One kid wants to keep living in it, another kid wants to sell it off, and the third one wants to keep it as a rental. And they all get in a big fight. The same sort of scenarios can occur with intellectual property rights. The dad leaves a patent, he's licensed it out to Intel, it's making $50,000 a year, but who's gonna, the contract says certain people have to pay the maintenance fees. And then what if Triquint comes in and says, we want to buy that patent for flat out $1 million? Who's going to make that decision if there's three owners in it? That is something that is better managed ahead of time. And the common way to do it is to take these sort of intellectual property rights and you put them in another company, you put them in an LLC or something like that, which manages those intellectual property rights. And it's not hard to do, and it's not that expensive to plan for that.
What about, let's say I make copies of an artist's paintings and sell them, and I've been given the rights to buy that artist. And a divorce comes up, and I, as part of the divorce, say, okay, I'm just going to transfer that to you. We were kind of working this business together, and I don't want to do this anymore. So you now have that right. And the decree, put it in the decree, and it goes on. Do you need to get permission from the artist again?
Typically, the contract is going to be some form of a license. And it's very common in these license agreements to say that the license is not transferable. And so that person who granted the license would probably object, because they could relicense it out for maybe a more favorable rate, especially in the context of exclusive licenses, which were originally licensed out at a very low amount, but then could become popular and they can license it out for much more.
It sort of dovetails into valuation. From everything you're saying, it seems like sort of the key is figuring out how to value intellectual property, no matter, whether it be a trademark or a copyright or a patent, not only at the time of the divorce, but as it goes into the future, and especially, like you said, if there's going to be some sort of stream of income.
Yeah, and the valuation ties directly to the right itself. In the case of a patent, you're granted a limited monopoly, quote unquote, for a period of 20 years from the date of application of the patent. So it could be, let's say the patent was issued 5 years ago, you might have another, roughly speaking, 10 years left on that enforceable patent. So what the value, what the period of time that you could potentially receive revenues on. Now, if the patent is coupled to a product, depending how the license agreement was written for the product, it's possible to write a license that covers not only the patented aspects of the product, but also the unpatented aspects of the product. So you might receive royalties indefinitely on the unpatented aspects of the product because of that agreement with the manufacturer. The most famous case of that was a toy that squirted out like Spider-Man type liquid, and the debate was over whether they had to pay royalties forever. For a copyright, it's a little different. The period of a copyright in some instances can extend in excess of a century. So you have a longer horizon of that copyright's worth value. And what typically happens is that if it's a singer, and more so as a writer, that they make a lot of money at the beginning when the song's released. It's a popular song. And then they make a lot of money when they die, because that's another triggering event where people go, oh, I just heard that artist X died. I really want to listen to their songs again. So it's those two events, which are usually separated by decades, which affect valuation significantly. The other thing that's affected valuation is the type of work, especially in view of the fact that the internet allows you to copy things for free. And so if the person has a sculpture, that's less likely to be copied than if somebody has a digital pop song.
So if a couple gets married, and maybe they both are artists and they each have some intellectual property, each maybe have some copyrights or something like that they own. Are there any sort of issues they might want to consider before they get divorced? I mean, while they're still, like you said, together, in terms of how to handle that even while they're married? I mean, is there some sort of issue that can arise?
Yeah, whether it's treated as separate property or they decide to make it part of the marital property, especially if there's going to be activities like paying maintenance fees or investing in those particular inventions or copyrights, that might affect how the court determines down the road, if there's a death or divorce, of what portion should be allocated to the non-creative spouse or the kids who get that intestate. Also, prior going into the relationship, it's good to talk to a tax attorney, especially if these things are generating lots of money, on how to treat particular things like copyrights, because how you transfer that interest or whether you keep the interest can affect the tax treatment of it. And what you don't want to have is have an unfavorable tax treatment down the road, especially on a copyright where upon death, you don't get things like the equivalent of a stepped-up basis or something like that.
So if someone comes to you and says, my spouse and I own this business, we've got, several licenses. Now looks like we're going to get divorced. What's the first thing we should do? What would be your answer?
Yeah, I mean, in the context of a business, it actually can make things a little easier. Is assuming that the business has been assigned the rights of the inventions, the patents. They are now the property of the business, and they can be dealt with in the context of the business. Likewise, for the copyrights, if the creative works were created under the auspices of the business, the ownership is generally considered as part of the business. But it's good to clarify that, because down the road, if anybody wants to clear title to these works, it's better to clear that title while it's still fresh in everybody's mind. And that means formally saying that these rights belong to this business. And when I'm saying business, it can be a corporation or an LLC, or it can be just a general partnership. But it's usually cleaner if it's part of a separate legal entity. Likewise with the trademarks, if the business is operating as its own, the rights are going to accrue to that business itself. And where things come up is usually less of an issue with married couples, but sometimes with family members, where you have, let's go back to my plumbing example. We have a thing, I won't call it Bob Plumbing, I'll call it Edmondson Plumbing. And I've got 3 sons, Jack Edmondson, John Edmondson, and Jill Edmondson. And they all don't get along, but they're all really good plumbers. And I die, and now I got 3 people who want to use the Edmondson name in Beaverton. Well, what is going to happen to that Edmondson name when we have 3 other competitors, and what's the goodwill associated, and what's the trademarks? That becomes a tricky thing that should be dealt with in the will, or the plan for succession on what's going to happen to the business in the context of the kids. Or it can be dealt with in the business part of itself through non-compete clauses.
It seems like that's really another huge reason, if you don't have a will, to make a will, because if you own something, intellectual property way, and you die without a will, and it may automatically split off and go a third, or half, or something like that, and who knows what that's going to end up causing.
Right. The evaluation of intangibles, intellectual property assets, and other assets in the context of probate, from my experience, is a lot more expensive than if you plan for it ahead. And from what my experience I've seen is it's orders of magnitude more expensive dealing with it after the fact rather than planning in advance.
So is there, I should say, someone like you, or you, that a person maybe should go to, in addition to their estate planning attorney, in addition to coming to us, when they have a piece of intellectual property that may have either issues of what it's valued at, maybe it's a patent that's never actually, it's been granted, but no one's done anything with it, or it's a license, that's exclusive to the testator. Can they come to you and kind of figure out the patent rules or valuations, and then go kind of back to their lawyer and say, okay, this is how we're going to split this?
Yeah. And it's usually best done through the estate planning attorney. But for example, let's use myself again. I'm 80 years old. I've got a bunch of patents. I got a bunch of trademarks. I got a coin collection, and I got a house. And the house is worth $1 million. The coin collection is worth $1 million. And then I've got all these other intellectual property rights that are generating some licensing revenue. Let's say they generate $200,000 per year. Those licensing revenues could go up over time, or they could decline over time. And if my question is, I got 4 kids, and how do I divide these things up fairly amongst the 4 kids? I know my parents were very big about dividing things equally between the kids. It's more difficult to say you each get a quarter of a patent than it is to say you get a quarter of a coin collection.
Right.
Just like with a house, you could say I'm going to give the house to all 4 of you kids, but then they get fights over what needs to be done with the house. So knowing what the value of that property is for the intellectual property is something that a patent attorney or an intellectual property attorney can help advise the estate's attorney on what this valuation is. And there are standards for it, saying, well, we think this song or this book is worth so much money.
Yeah. Gosh, 30 minutes just ran out. That was quick. This was really, really informative. And Kurt, thank you so much for joining us today. I mean, you provided insight on a complex issue and really made it easier for folks like me to understand. So thank you for coming today, Curtis.
Oh, thank you very much, Steve. Appreciate it.
Oh, I do too. And I also want to thank everyone else who tuned in today to today's Facebook Live. And if anyone has questions on today's topic, please feel free to post them here. Shoot me an email at saltishin@pacificcascadefamilylaw.com. And I will kind of shoot them over to Curtis and maybe see if somebody can get together. So always, until next time, stay safe, stay happy, and have a great day.
Thank you, Steve.